All of these will directly contrary to the equality principle of Article 14, 19, 21, so many of these things. And coming to...
They are not contradictory. They have been very well explained.
They have been explained, Your Lordship.
Reservation is not contradictory to Article 14 at all.
Reservation, Your Lordship. Yes, okay, Your Lordship. These were the legislations made in favor of the minority sects for the past 70 years. And they have been included in the 9th schedule to be away from judicial scrutiny as well. Otherwise, why would the 9th schedule be in place, Your Lordship?
So, the legislature has an apprehension. Otherwise, it may be thrown by the moot. Unless the protection
that is the contention of the respondent itself, Your Lordship. The legislature has that apprehension, and that's the...
Yeah, by the way, one question. How many amendments so far the Indian Constitution? What is the last amendment?
In respect to the 9th schedule?
No. What is the last amendment made in Indian Constitution so far?
Your Lordship, I'd like to
refer 108 of the present imaginary what about the amendment of the Indian Constitution? Last one.
The interest of the national 106. 106, Your Lordship.
And please look into the slip.
Says 106.
Absolutely correct. Yes.
Lordship, I am arguing.
Without borrowed wish to be answered. Okay, continue. Yes.
Your Lordship, yeah. Coming to the whole aspect of the subjective interest of national religion that is coming to question in this case has been put on by Your Lordship. Also in this case, this is merely a reasonable restrictive. The state has always been passing laws in interest of minority sects, regardless of being inside the 9th schedule or outside the 9th schedule.
The constitutional bench is not binding on the legislature.
No, Your Lordship.
While making subsequent laws.
Your Lordship, the council stating that the minorities of the state has never been aloof. Where the one aspect of secularism is also that the state should not be included, not be involved in the whole religious aspect. But that's what the state has been. There have been various legislations passed inside the 9th schedule and outside the 9th schedule. Your Lordship, there are so many. So the whole crux.
That is per se illegal against the racial laid by the Supreme.
Yes, Your Lordship, contending to the same fact that in this present case, the majority are just coming with a plea that yes, can the union and the state also pass laws in the interest of us without demoting the constitutional rights of the minorities. So, how the state has been passing laws in the interest of the minorities, inclusive of the 9th schedule or exclusive, Your Lordship?
What is the harm without the amendment at present?
What is the harm without the amendment present? Your Lordship.
We ignore the amendments. Unamended provisions.
Coming to this crux of this case, the 80% majority in this case are contest violation is uncurbable and the government, yes, Your Lordship, the government could have proclaimed emergency, worse detention, all of that could have happened. But what the government did in this case is to just stop the violence by merely
stating whether the state has the data of persons who were normally, otherwise, compulsorily converted. Where is the data?
Your Lordship, can you please repeat?
What is the data showing that after independence, there are multiple conversions, which are all...
Your Lordship, this is not in relation with conversion.
Voluntarily and the other for major portions.
I mean, this amendment
is compulsory. Any data from the government?
Your Lordship, this amendment...
What after the legislature go for legislate?
Yeah, Your Lordship.
Without any data and subjects.
Your Lordship, the amendment in this case is to understand where the majority sect are coming from, to form more of a increase the more culturality of the majority, where a nominal national and conversion
without the amendment. What is the harm?
Your Lordship, this is a harmless convention that has been put forth.
So why should we interfere with the
Your Lordship,
peaceful situation by
this is not a peaceful situation.
Make the situation the fundamental intention is to prevent a forced conversion and others.
No, Your Lordship.
Why prevent this forced conversion without making any amendment in the preamble?
Your Lordship, this and conversion is not related.
What necessitated the deletion of secularism?
Your Lordship, there were two issues in hand in this case. So the majority sects were not feeling recognized enough. They were not feeling valued enough by the states. And the second problem was the conversion. To deal with both these things, to deal with the entire cultural 1950, what the government did is they came up with this amendment where they proclaimed an act, and they are declarative
You
business.
have you are arguing a very
The amendment, major amendment, and the citizen is allowed.
How do you justify deletion of socialism? Let's say socialism in the context of the environment,
The aspect. Yes, Your Lordship.
how
This
do
is
you
something,
justify this deletion of socialism?
Your Lordship, coming to the aspects of the constitutional drafters, the intent that I was talking about in the debate, where the words, there is rationality behind why socialism was not added in the initial stages itself. I was elaborating in the beginning of my arguments on why socialism should not be a part of the constitution and the intent. The socialism cannot be laid down because it's it is an evolving, it is emerging, and this is the whole reason behind Dr. Ambedkar.
this is very full of question because socialism is a harmless idea being followed throughout the nation and throughout the whole world. Then why you remove it? You want to make the earlier system of slavery.
Your Lordship,
So
your,
you cannot,
no, no, no.
you cannot compare socialism with communism. Socialism refers to the
The majority or substantial part of the 42nd Amendments were removed in 44. These were retained.
Yes, Your Lordship, these were.
Tourism is being valued of propagation, profession, and practicing religion. But the whole aspect of the union state, they are being involved in worship, they are being involved in religion. That is really what is being taken out. But
non-religious country to a religious country.
yes, Lord, that was that
This
is.
change is not on affected the race.
Can you please repeat? I could not hear you.
Please listen. The framers of the Constitution expressly rejected the view to make this country as a religious country. What they intended is to keep this country throughout as a non-religious country. Then what is the justification for you to argue that when there is socialism, stays still, aloof from the religion. That is what is intended by the constitutional framers, and that is what is intended by introducing socialism and secularism by 42nd Amendment. Then, how can you remove the basis structure itself? And on the basis of that basis structure intervention, pass laws by the legislators to make the country so that majority is given supremacy over the minorities. That is against the fundamental tenets of the constitution.
Your Lordship, yes, we have made all these amendments now, but have any of the amendments made an interest to the minorities been repealed? No, Your Lordship. All the 284 legislations, inclusive in the 9th schedule, reservation inclusions, and all of this still valid, Your Lordship. The minorities are still getting their rights. Minorities still have various legislations that encourage them and promote them.
Is there any situation whereby any majority members are denied of the right?
Your Lordship, exactly. The whole.
Make the question. Minority is getting the right. Keep it as such. Any complaint that the majorities are not getting their right.
Your Lordship, the whole reservation aspect was on debate, Your Lordship. Unfortunately, I'm not going to pronounce the constitutional debate on that.
Similarly, each time amendments are
There
decided.
various, so 9th schedule itself was in a whole discrepancy, Your Lordship. Your Lordship, if you look at that, that is my contention, Your Lordship. The fact that the state is not, there is a whole dispute on the whole idea.
Do you agree that the present amendment is not in violation of Keshavananda violation ratio?
Yes, Your Lordship, because the core principles of secularism that was intended by the framers of the Constitution are still present. A citizen is able to practice propagating from his religion, and yes, it is subject to reasonable restrictions towards the national religion, but this freedom is still being clearly emphasized by every citizen of this country, Your Lordship. That is what the respondent is trying to contend in this case. And
There are certain citizens, they don't have belief in any religion. Whether your amendment includes them,
Your Lordship, here the
your amendment says we have this religion, this is our national religion. Apart from that, we have 4 other religions also. Nothing, no reference regarding those people, what it is. They are not believing in any religion. How do you rate them?
Your Lordship, they will be executing their fundamental rights.
Going to majority community or the minority community to live in India, or their freedom to continue as a non-religious man is taken away.
Your Lordship, coming to that extent of this case, if we are looking into it that deeply, every citizen of this country is eligible for fundamental rights. Basic constitutional right is not been revoked, Your Lordship. It is not.
In fact, not covered by the minimum facts. Correct.
Yes, Your Lordship. And our constitutional rights are, and every citizen of this country is eligible, Your Lordship. In this case, what the government is contending is that as we
No propagate, profess any religion, and also not propagate, not profess any religion. No situations.
in no such situation. It is to the discretion of every individual. The government
It's
has
not
no.
protected.
No, fundamental rights are protected for all citizens, regardless of them following religion or not. That is,
Then why this amendment?
this amendment is in place.
You are amending and deleting secularism. Shouldn't it be necessary for you to delete liberty of belief, faith and worship? That is another word in the prayer. Liberty of belief, faith and worship.
Your Lordship, I would again like to reiterate that the word secularism
And
is taken out.
what would remain of fraternity? Because if there is no secularism, there is no point in retaining the word fraternity here.
No, Your Lordship. The contention of the respondent
Liberty
council.
and fraternity can also be taken.
No, Your Lordship. The principles of secularism are being retained, is what the respondent itself is contending. So when we are retaining the principles, why would we want to remove the liberty and fraternity itself, Your Lordship? The reason we took the word, preamble itself is not part of the basic structure, Your Lordship. It can be amended as per the land management of bravery, case and all that. Here we are only arguing about the.
So as to effectively implement your objectives, you may have to take away these also. Merely taking out secularism,
Your Lordship, the
maybe
principle.
socialism, would not enable you to achieve your objectives.
Your Lordship, coming to the intention of the constitutional drafters, the principles of secularism and socialism are retained, is what I contested.
One situation. The time the constitution was introduced for the first time, so socialism and secularism were not there.
Yes, Your Lordship.
Introduced for the first time by 42nd Amendment of
Yes, Your Lordship.
Okay. Simply imagine, as per the 46th Amendment, some other amendments brought into the beginning. Then also secularism and socialism retained. What the point? Here what we have done, if we are removing the words much harmful to the minorities, it will become more harmful when you have taken the constitution to a constitution which never intended by the legislatures, because they ruled out the possibility of the religious state. So you are now attempting to introduce a provision to efface the earlier attempts made by the Constitutional Assembly, subsequent judgments, and the prescription that this mighty country has been following for years.
Lordship, I would like to address this question. Coming to the entire aspect, in the intent makers of the Constitution itself had mentioned that secularism is an evolving principle and it is reflective of the will of the people. Coming to that aspect of the intention, the Lordship, if they were so sure that yes, Your Lordship, at that point of time the circumstances led to the fact of not requirement of a national religion, but the circumstances are completely different 70 years down the line. In this date and age, as the majority is also seeking some remedy from the state, the way the minority has been seeking for all these years, because the minority has been seeking so many legislations in their favor for 70 years, but the majority is just asking the minority that pass legislations in favor of us also without breaking the constitutional rights of minorities. So, therefore, the idea of a national religion has come into place. This was not the circumstance at all 70 years before, and that's what the intent of the constitutional drafters. If they were so sure that this is what they want, they would have had secularism in itself.
How much time do you want?
Your Lordship, as per Your Lordship, we should have it.
Please conclude as please suggest 3 minutes.
Yes, Your Lordship. Coming to the intent, if they were so bent on keeping the state secular, the SR Bhumai judgment that came 30 years down the line, keeping the state aloof, or the word secular would be implemented in the constitution then itself. But coming to the intent, they had clearly mentioned that secularism and socialism are evolving and they are reflective of the will of the people at that time and date. And that is what has been taken into consideration by the respondents in this case also, where the constitutional rights of every citizen is being maintained. And
how will we evaluate the will of the people? What is the methodology?
Methodology to evaluate the will of the people.
Tell me.
Can I speak in relation with this case itself, Your Lordship?
See, you are very much canvassing the majority of the will of the people. What is the criteria to assess it?
Your Lordship, if the intention of the government was to canvass the will of the people, majority alone.
Canvassing is different from making it as the will.
No.
You can canvass, maybe your will. That is a demand.
Your Lordship.
Then, making the other one, person comes and says, my will is this, then that is the will. Compelling or suggesting or influencing to be his will is different from the will, which is one of the will. Then what is the criteria?
Your Lordship, coming to this case itself, if the government.
That is why this aspect is foreseen by the legislature. That is why, in order to pass a constitutional amendment, 2/3 majority is insisted. That means 2/3 of the members of the parliament who were elected by the people may have the idea that they are giving this huge mandate to do something. But such exercise is permissible only when there is 2/3 majority. Otherwise, it is perceived like that. Correct? Then you are will of the people and that defense may go.
Your Lordship, the same thing has happened in this case. This amendment has taken place the due procedure. The majority president had assented the bill. All of that had taken place in this case also, Your Lordship.
Presidential assent is not the majority of the bill.
No, Lordship.
That is the decision of the president as per the constitutional mandate. Right. Once the president has the right to return, sometimes twice, but it is third is bound to accept it. We are not propounding a presidential form of government in India. We are prime ministerial form of government,
Yes, Lordship.
supported by council of ministers and the elected legislative.
Yes, Your Lordship.
Their mandate is the predominant one. President has no independent predominance over their mandate. That would apply in cases of the governors of the state also.
Your Lordship, similar circumstances have taken place in this case also in factual matrix. And with only the equal advice of the President and the Council of Ministers, the President has assented this bill. All of that has been taken into due consideration, Your Lordship. This bill was not arbitrary in any sense. All the due procedure to pass and make any amendment under Act 368 and the whole procedure behind the assent of the bill, the President's also
I
taken.
felt that your argument might have been missed. The instant case, even though Muslim passing of this provision are imagined, they aimed to be passed by two-third majority.
Yes, Your Lordship.
Then there is will of the bill. And measuring your answer, that is,
Okay, right, Your Lordship.
they are imaginary facts.
Facts. This is right. This has been clearly established in the facts itself. So I based my arguments on the word secular intent because that was in question, Your Lordship. Because yes, Your Lordship, the due procedure has been followed. The advice of the President and Council of Ministers has also been followed. But that would be a very weak argument as it's already there in the factual matters. It's just due procedure. I mean, I know the argument for the respondent was to analyze the secularism and socialism intent from the incorporation till this date. That Can you please repeat?
I conclude. Your remarks, concluding remarks and prayers or release that you have sought. Anything.
Your Lordship,
You may conclude.
okay. Much obliged, Your Lordship.
You must have a conclusion.
Yes, Your Lordship. With assumption of the fact that secularism principles have been maintained and the social and also the fact that the rationale behind the socialism that has not been incorporated, the principles of socialism have also been maintained. The Council of the Respondent have come to a conclusion that the basic structure has not been struck down in this case. Essentially due to the fact that starting from the intention of the drafters, the land legislation of the party is not done, and even recently in September 2024, Tamil Nadu government R&D noted that the secularism is a European concept and not Bharatian. But in the 42nd Amendment Act, Indira Gandhi had not.
You have not answered about that. Subject to the interest of the argument.
Much of that was in, I had mentioned that at the beginning of the arguments itself, that yes, subject to the interest of national religion is being
That is second point you are being interested by your colleague. So you must
I had meant
argue that by 2-3 sentences.
Yes, Your Lordship, coming to the interest, again I will give that answer. Coming to the interest of the subject to the interest of the national religion that has been incorporated in 25. Your Lordship, a citizen is still able to freely practice, propagate and profess religion. But the subject to national religion in this phrase is, the jurisprudence behind this is that he is not getting, a minority religion is not getting his rights curtailed. He is just having a reasonable restriction. A reasonable restriction, that is what this phrase is coming to. If he wants to propagate his religion, he can more freely do it. But there is a reasonable restriction on his part that his propagation cannot demote the national religion. Or the same example will follow for practicing and profession. And that is what this subject to national religion, the jurisprudence behind the government is coming into place. That is what we would like to give the rationale behind this new faith that has been amended in Article 24.
You are evaluating regarding the relations throughout the world where religion supersedes over anything, and where religion has no role, where the peace is not, where the peace is not.
The priest is
This is the peaceful country, whether religious country or non-religious country.
coming to the
Please,
entire.
please tell from your experience.
Lordship.
Please compare. Please compare between India and Pakistan. Pakistan is a religious country. Very upset country. No peace, nothing. Anybody can die at any moment. No control, nothing. Anything can happen anywhere. See the case of India, non-religious country. The atrocities are comparatively less. The rights of the people being protected normally. Everywhere when the number of population is more, slight difference, slight inclusions in applies. Apart from that, what is India being a non-religious country is more effective, more powerful, more good to the citizens. Why should make it as a religious country and take experience of a religious country? They are all fully suffering from some sort of democratic, denial of democratic values.
Your Lordship, yes, if you take Pakistan into consideration, that will be the example that we can use.
Yes, regarding Bangladesh, Afghanistan, Saudi Arabia,
Your Lordship, coming to the fact that India,
then Malaysia, Japan, Indonesia,
yes, Your Lordship,
all religious countries are facing threat to the rights of the citizens. But when there is no religion, no command for the religion, that should be left free. That is the best country, best democratic country in the world. So we must be proud to say that we are Indians and our country is the best country in the world.
Your Lordship, this country is still very proud to withhold the secularism principles. Your Lordship, in this country, the constitutional right for every single individual, like I mentioned, and Your Lordship also put forth, what about a person who does not follow the religion also? Your Lordship, atheists in this country has full rights to enforce fundamental rights. In this country, yes, the government had converted this country to a national religion. But coming,
Pakistan, please take the former president, 8 of the former presidents, prime ministers, chief justices, etc. Majority of the jailed or killed by the
Your Lordship,
administration. See the case in India.
yes, Your Lordship.
What a constitution we are having is a beautiful constitution which protects everything. That is why we are living so happy.
Yes, Your Lordship.
Apart from certain minor accidents. That may happen wherever the population is too high.
So, Rashid, coming to the aspect of this case, instead of in this case, what has been taking place is the violence is uncurbable in this case. What has been taking place in this case is the violence uncurbable that the government, regardless of trying and forcing, is not able to curb the violence. The majority of people are rioting and it's happening throughout the nation. That is what is happening in this case. So, in this case, it's a similar relation of what is situation is what is happening in Pakistan, in fact. And what the government is doing in this case is coming with two ideas. One is to get this movement, regardless of keeping national religion and nominal religion as Hindutva, etc. The government is still clearly stating that the state cannot demote the constitutional rights of any other recognized religion. This is clearly stated in section 3 of the 12th Amendment. This is not there in Pakistan, Your Lordship. A minority man can approach the court if his constitutional rights are demoted. Violation comes next. Demoted itself, he can approach. If the state is demoting his constitutional rights, he is approaching the state, Your Lordship. This is still being granted to every citizen, regardless of the national religion being in place. That is, yes, the situation is.
The amendment is absolutely unlawful.
Your Lordship, this is there. This amendment is.
If you are missing on the second part, the first part is unlawful.
No, Your Lordship.
Even though stressing on the second part, the legislature is otherwise, and the first part is very, very.
No, Your Lordship. The first part was.
Need to be weak.
No, Your
How
Lordship.
it will happen.
Your Lordship, I have explained my rationale behind the first part, Your Lordship. The subject to illness is a reasonable restriction. So the rationale behind the first part is being given by the respondents. Now only I am coming to the second part, which clearly states the constitutional rights to not be demoted. Therefore, the council has addressed both. Yes,
By saying that these petitions are Indian species. Okay.
Your Lordship, if Your Lordship is satisfied with all the. I would like to go on to the prayer of the respondents.
One dismissal. So that I may do something else.
Yes.
Yes. Other side,
Apologies, Your Lordship.
First time, please come. 2 minutes.
Your Lordship, with regard to my learned counsel, I have a few questions for rebuttal. With regard to their page number 21 of memorial, paragraph 2.1.1, they have the 108th Amendment Act 2024 does not violate the basic structure doctrine. They have substantiated the same by saying that there was violence in the country, and in order to curb the grave violence in the country and protect the minority sections and pacify the majority, the government had to pass laws that maintain peace and integrity in the country as well as uphold the principles of socialism and secularism. Your Lordship, they have explicitly mentioned that in order to pacify the majority, they have implemented such a 108 amendment. In order to curb the grave violence that was existing in the country, they had to pacify the majority, Your Lordship. In order to pacify the majority, they have themselves agreed that there was a need to promote national religion in favor of the majority population, Your Lordship. Further, I would like to ask the learned council who reasoned that the reason why we had to approach the committee, that is the scrutiny committee, the learned council said that they will be asked, why are you converting? The reason is why are you converting and not whether they have there is consent in the said conversion. Your Lordship, with respect to the scrutiny committee and with respect to my learned council's arguments, why are you converting and not whether if the said person has given their consent or not, Your Lordship. Further, with regard to the Jharkhand anti-conversion law that my learned council mentioned, the provisions of the said Jharkhand Act contains three main provisions as I mentioned earlier during my submissions. First is a prohibition on conversion. Second is a notice requirement on the declaration by the person who is converting sent to the district magistrate. And third is the burden shifting provision onto the person who converts the said person. Your Lordship, these are the questions for rebuttal. Much obliged.
The answer from your part.
This is the answer. This is what we are replying to this submission. Anything over on your side? What do you need? You have anything, please comment.
Your Lordships, the Council would like to address the rebuttals alone and not anything given in their memo or their pleadings. So whatever they brought up in their rebuttals alone shall be addressed by the Council. So Your Lordship, they mentioned that we are trying to pacify the majority in this. However, that's not the submission that we have given. Yes, the memorial did have the same, but Your Lordship, in their rebuttals, they had nothing to say with respect to the constitutional amendment based on the submission that we gave. So that is a clear indication that whatever that we gave was substantially convincing and they had to resort to the memo for the same. And as to the second reason, the learned counsel for the petitioners mentioned that the state is asking why are you converting and not whether there is consent, Your Lordship. Now there is a reason why the council framed the question as why are you converting, because it's not only consent, because it's a multifaceted concept, Your Lordship. When you're converting, you need consent, you need to make sure that they understand what they are getting into along with the other factors that you mentioned. So the consent is part of the reason as to why they are converting, Your Lordship. In fact, the council ministers and the